Hello, I'm Kent Morlan. I'm an attorney. I practice law in Tulsa, Oklahoma, and I'm also the editor and publisher of an internet-based legal newspaper called morlaw.com. Among other things, Morlaw collects and publishes civil and criminal litigation-related information from the state and federal courts nationwide. We also collect information about the lawyers involved in the litigation of the cases. I've chosen today to talk about basically car wreck litigation. Now, car wreck litigations they're referred to as torts by lawyers, which means wrong. And in the operation of motor vehicles, all of us have a legal responsibility, exercise due care in the operation of our motor vehicles so that we do not cause harm to other people. And so if you're driving down the road and you stop and somebody doesn't stop and they run into the back of your car and you are injured, they have committed a tort against you. And under the tort law of most states, you have 2 years in which to file your lawsuit if you're going to sue the negligent operator of the motor vehicle to recover your damages. And generally speaking, you can accuse the driver of inattentive or distracted driving, improper lane changes, driving on the wrong side of the road, speeding too fast for then existing conditions, speeding, failing to brake, failing to keep a proper lookout, failure to warn, careless driving, reckless driving, etc. All of those violate the rules of the road and are the basis of negligence actions. Now, generally speaking, the plaintiff will file suit in state court if, for example, a resident of Kansas, for example, got sued by a resident of Oklahoma in an Oklahoma state court, and the amount of controversy was in excess of $75,000, the resident of Kansas could remove the case to federal court. Or if a resident of Oklahoma was in Kansas and had a wreck caused by a Kansas resident, the Oklahoma resident could file in federal court. A Kansas resident harmed by an out-of-state person cannot remove to federal court because the theory behind the federal court system is basically that the federal courts would be more fair in treating foreigners than the state court would. Generally speaking, the damages that are recoverable in an automobile accident are physical pain and suffering, past and future, mental pain and suffering, past and future. The age of the plaintiff can be taken into consideration. Injuries sustained based upon his or her physical condition immediately before and after the accident, the nature and extent of his or her injuries, whether the injuries are permanent, physical impairment, disfigurement, loss of earning and or time, impairment of earning capacity, reasonable expenses, necessary medical care, services past and future, and so forth. The defendant can also claim that the plaintiff was negligent. Most states have comparative fault anymore, but some still have contributory negligence. Contributory negligence is a bar to recovery, and most places still retain it. Comparative fault will be the recovery will be based on whether the defendant was more at fault than the defendant. If you have been injured in a car wreck, I recommend that you wait not more than a year before you contact an attorney. And certainly you can contact one sooner than that. But you want to give your attorney plenty of time to acquire all of the information necessary, put together a petition, file a lawsuit, and make service of process on the defendant. Thank you. You have a good day.